of record as the court the records of which are admitted to be of evidentiary value, and they are not to be questioned when they are produced before any court. Supreme Court is a court of record. What is Supreme Court? It is a court of record. It is stated in which article? It is stated in Article 129 of the Constitution of India. Dr. Ambedkar defined a court of record as per the definition of the Dr. Ambedkar. Court of record, courts the record of which are admitted to be of evidentiary value, and they are not to be questioned when they are produced before any court. Court of record means whose record cannot be questioned, whose evidentiary value cannot be questioned when they are admitted before any court. Court of record which are admitted to be of evidentiary value, higher evidentiary value. That means Supreme Court's precedent shall act as a evidentiary value, and the precedent cannot be questioned when they are produced before any court. Article 129 further says that Supreme Court shall have all the powers of such court, including the power to punish for contempt of itself. Supreme Court, as per 129, is the court of record and has all the powers, including power to punish its contempt of itself. Dr. Ambedkar described this power as a necessary consequence from the status of a court as a court of record. Jurisdiction. Supreme Court has three kinds of jurisdiction: original jurisdiction, appellate jurisdiction, advisory jurisdiction. Original jurisdiction of Supreme Court. Article 131 deals with the original jurisdiction of the Supreme Court. The Supreme Court shall, to the exclusion to any other court, have jurisdiction to any dispute between the Government of India or one or more states, or between the Government of India and any state or states on one side and one or more other states on the other, or between two or more states. Jurisdiction of Supreme Court shall not extend to following matters: a dispute arising of a treaty, agreement, covenant, engagement, squad, or other similar instrument which have been entered into executed before the commencement of the Constitution, continuing operation after such commencement, or which provide that the state jurisdiction shall not extend to such a dispute. Article 139. Under Article 262, Parliament may by law exclude the jurisdiction of the Supreme Court in dispute with respect to use or distribution or control of the water of any interstate river or river valley. Matter referred to Finance Commission are also excluded. Matter referred to the Finance Commission are also excluded from the original jurisdiction of the Supreme Court. It is enshrined under Article 280 of the Constitution of India. The adjustment of certain expenses between Union and State. Article 290. In Union of India versus State of Rajasthan 1984, the Supreme Court held that the suit for the recovery of damages against the Government of India is not under Article 131 of the Constitution. The Constitution 44th Amendment Act 1978 substituted a new Article 139A, which empowers the Supreme Court to transfer case from one High Court to another High Court if it is expedient to do so for the end of the justice. Clause 2 provided if on an application made by the Attorney General or by a party to such case. Hi, welcome Sammy. The Supreme Court is satisfied that it involves a question of law or such question are of general importance which is pending before it or before one or more high courts may withdraw the case and dispose it itself. Article 32 confers original jurisdiction on the Supreme Court whenever there is an infringement of any of the rights conferred by Part 3 of the Constitution. Fundamental rights. The Supreme Court can issue writ for the restoration of fundamental rights. These writs may be in the nature of habeas corpus, mandamus, certiorari, quo warranto, and prohibition. Appellate jurisdiction. Article 132 says that an appeal shall lie to the Supreme Court from any judgment, decree, or final order of a High Court in the territory of India, whether is in a civil or criminal proceeding or other proceeding, if the High Court certifies that under Article 134A that the case involves a substantial question of law as to interpretation of this Constitution. Thus, the appellate jurisdiction of the Supreme Court extends to three branches: civil, criminal, and constitutional. Appellate jurisdiction in civil cases. An appeal shall lie to the Supreme Court from any judgment, decree, or final order in a civil proceeding of a High Court in territory of India if the High Court certifies under Article 134A that in the opinion of the High Court the said question needs to be decided by the Supreme Court. 30th Amendment removes the condition of monetary value that an appeal could go to the Supreme Court only when the amount or value in dispute was not less than 20,000. Under Article 132, now an appeal will lie in the Supreme Court only if the High Court certifies under the new Article 134A that the case involves a substantial question of law of general importance. The requirement under the amended article is very strict and both the conditions must be fulfilled. Appellate jurisdiction in criminal case according to Article 134. An appeal lie to the Supreme Court from any judgment, final order, or sentence in a criminal proceeding of a High Court in the following ways: with a certificate of the High Court or without certificate of the High Court. Number one condition for first condition with a certificate of High Court under Clause C, an appeal lies to the Supreme Court if the High Court certifies under Article 134A added by the 44th Amendment 1978 that it is a fit case for appeal to the Supreme Court. It is mentioned under Article 134 Clause C. Under the new Article 134, a High Court can grant a certificate for appeal to the Supreme Court under Article 132 either on its own motion or an oral application of the aggrieved party immediately after passing the judgment, decree, or final order. Prior to this, the High Court do so only on the application of the aggrieved party. Under new Article 131A, it can now grant a certificate on its own motion if it thinks fit. If it deems fit, without a certificate, has on appeal reversed an order of acquittal of an accused person and sentenced him to death, has withdrawn for trial before itself any case from any court subordinate to its authority, has in such trial convicted the accused person and sentenced him to death. But if the High Court has reversed the order of conviction and ordered the acquittal of an accused, no appeal would lie to the Supreme Court. मैंने 100 गुनहगार छूट जाए लेकिन एक बेगुनाह को सज़ा नहीं मिलनी चाहिए, वही चीज़ यहाँ पे दिखता है कि बिना सर्टिफिकेट के भी अपील कर सकता है। अगर एक्यूज्ड को डेथ का सेंटेंस दे दिया है, उसको एक्विटल का रिवर्स हो गया उसका ऑर्डर, ठीक है, वैसा ही अगर सिमिलर केस होता है सबऑर्डिनेट केस में जिसमें ट्रायल में जो है उसको कन्विक्ट करके सेंटेंस कर दिया, डेथ को सेंटेंस दे दिया है, तब अपील जाएगा बिना सर्टिफिकेट के भी। लेकिन अगर एक दोषी को निर्दोषी साबित कर दिया गया तब नहीं जाएगा अपील। Under Article 134 Clause 2, the Supreme Court has not been constituted as a general court of criminal appeal. It would entertain appeal from the judgment of the High Court only in exceptional circumstances, when there is likelihood of injustice to be caused to the party. Siddheswar Ganguly vs. State of West Bengal, AIR 1958 SC 143. Under Article 134 Clause 2, the Supreme Court does not interfere with concurrent finding of facts unless there is any infirmity. P. Umad Narayan vs. V.K. Carson, AIR 1971. Appellate jurisdiction constitutional matters. An appeal shall lie to the Supreme Court from any judgment, decree, or final order of a High Court in the territory of India, whether in a civil, criminal, or other proceeding, if the High Court certifies that the case involves a substantial question of law as to the interpretation of the Constitution. When such certificate is given or such leave is granted, any party in the case may appeal to the Supreme Court on the ground that any such question as aforesaid has been wrongly decided, and with the leave of the Supreme Court on any other ground. Article 132. Clause 2 of the Article 132 now been omitted by 44th Amendment Act 1978. For the purpose of this article, the expression final order includes an order deciding an issue which, if decided in favor of the appellant, would be sufficient for the final disposal of the case. Article 132. Notwithstanding anything contained in this chapter, Supreme Court may in its direct discretion grant special leave to appeal from any judgment, decree, determination, sentence, or order in any case or matter passed or made by any court or tribunal in the territory of India. The above provision is not applicable to any judgment, determination, sentence, or order passed or made by any court or tribunal constituted by any law or under any law related to armed forces. Article 136. In Election Commission vs. Venkata Rao, EIR 1953, Supreme Court 210, it has been held that an appeal from the decision of a single judge will not lie in the Supreme Court. Article 132. Advisory jurisdiction. Article 143 provides that if at any time it appears to the President that a question of law or fact has arisen, and is likely to arise, which is of such a nature and of such public that it is expedient to obtain the opinion of the Supreme Court upon it, he may refer the question to that court for consideration, and court may, after such hearing as it thinks fit, report to the President its opinion thereon. President may, notwithstanding anything in the provision Article 131, refer the dispute of the kind mentioned in the said proviso to the Supreme Court for the opinion. The Supreme Court, after hearing it, report to the President its opinion as it thinks fit. The use of the word may in the Article 143(1) indicates that the Supreme Court is not bound to answer a reference made to it by the President. In Re-Kerala Education Bill AIR 1958, Supreme Court 956. However, the Supreme Court in Re-Special Court Bill 1978 AIR 1959 SC 478 has held that the court is obliged to give its opinion under Article 143 of the Constitution. It is not noticeable that the advisory opinion of the Supreme Court under Article 143, though entitled to great respect, is not binding on courts. This view has now been changed in the case, and Supreme Court expressed the view that the opinion expressed in the exercise of advisory jurisdiction is binding on all court. See special reference number 2002 AIR 2003 SC 187 SC only 87. Power of the Supreme Court. The Supreme Court can review its own judgment or order under Article 137. A review will not lie in the Supreme Court on discovery of new review will lie in the Supreme Court on what condition? If a new and important matter is discovered or evidence discovered. Number 2, mistake or error apparent on the face of the record. And number 3, any other sufficient reason. In the R.D. Sagar vs. V.V. Nagari AIR 1976 SC 2183, the court pointed out that the judgment of the final court is final. A review of such a judgment is an exceptional phenomenon, permitted only when there is a grave and glaring error is made out. The law declared by the Supreme Court shall be binding on all the court within the territory of India, Article 14. But the Supreme Court is not bound by its own previous decision. It is clear that the doctrine of stare decisis is not strictly followed in India. Any decree or order passed by the Supreme Court shall be enforceable throughout such territory. Supreme Court may take any order for securing the attendance of any person, the discovery or production of any document of itself. Article 142. All authorities, civil and judicial in the territory of India shall act in aid of the Supreme Court. Article 144. Aforesaid powers are however not exhaustive and final. Parliament may by law enlarge the jurisdiction and powers of the court with respect to any of the matters in the union list. The Government of India and the Government of any state may by special agreement, if the Parliament by law provides, still further enlarge the jurisdiction of the court. It is enshrined in the Article 138 of the Constitution of India. The Article 139 provides that the Parliament may by law confer jurisdiction on the Supreme Court to issue writ or orders on matters other than fundamental rights mentioned in Clause 2 of the Article 32. According to the newly substituted Article 139A, Wide 44th Amendment Act 1978, the Supreme Court can transfer certain cases. 139A lays down where the case involving the same or substantially the same question of law are pending before the Supreme Court and one or more high courts or before two or more high courts, the Supreme Court is satisfied on its own motion and on application made by the Attorney General of India or by a party to any such case that such question are substantial question of great importance. The Supreme Court may withdraw the case or cases pending before the High Court or High Courts and dispose of all the case itself. Supreme Court may, if it deems it expedient to do so for the end of justice, transfer any case, appeal or the proceeding pending before any High Court to any other High Court. What are the conditions? According to 140, Parliament may confer supplementary powers necessary for the effective exercise of jurisdiction of the court. Rule making power of Supreme Court. Subject to any law made by the Parliament, the Supreme Court may from time to time, with the approval of the President, makes rules for regulating the practice and procedure of the court, and also the rule as to the proceeding in the court under Article 139A. Article 145 mentions about it. So that's all about this video. If you find it useful, like